This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. All right, fine. I'll do the legal Lamprey one too. It'll take a few minutes here. We'll do a Liebowitz sanctions dual feature. So Liebowitz was up for sanctions again, this time in the Southern District of Illinois in a case brought by Jesse Ward against Consequence Holdings. No, I don't think we know those parties at all. This action stems from unauthorized use of a photograph copyrighted by Jesse Ward, a freelance photographer from New York, and it was used by Consequence, an entity based in Chicago, Illinois. Following Consequence's use of Ward's photograph in 2016, Ward retained as his counsel Richard Liebowitz. On September 17, 2018, Liebowitz filed a complaint against Consequence in this district court, alleging claims under the Copyright Act and seeking monetary damages. Alex Young, founder of Consequences, received the complaint October 2018, contacted Liebowitz, and began negotiations regarding a settlement, conceding that Consequences' use was unauthorized and offering to pay Ward's standard rate. The parties verbally agreed to extend the deadline for responding to Ward's summons, though no request for an extension was filed in this court. On October 25, 2018, Young wrote to Liebowitz arguing that this court was an improper forum, meaning bad location, because Consequence was based in Chicago, the Northern District of Illinois. Liebowitz did not respond to this letter, and no further communication between the parties appears to have occurred until December. The court, unaware that any communication had occurred, threatened to dismiss the case for lack of prosecution unless notice of proper service to Consequence was provided. Upon notice being entered, the court again threatened to dismiss for lack of prosecution unless Ward moved for a default judgment, noting that Consequence had failed to answer the complaint by the deadline on October 16th. Accordingly, Ward moved for entry of a default judgment January 24th, 2019, and the court subsequently entered a judgment. Ward failed to comply with local rules, however, which require notice of default to be to defendant's last known address. Thus, Consequence did not become aware of the entry of default until July 2019. Consequence, which seems to have been unrepresented to this point, appears to have retained counsel, Dan Booth of Dan Booth Law in Concord, Massachusetts, entering an appearance on August 2nd, 2019. On the same date, Consequence moved to set aside the entry of default, its first filing in this case. The court set aside the entry of default, noting Ward's failure to provide notice to Consequence and Consequence's argument that the court lacked personal jurisdiction and appeared to be an improper venue. After default was set aside, Consequence moved to dismiss for lack of jurisdiction, further asking this court to enter an award of attorney's fees against Liebowitz, Ward's counsel, pursuant to 28 U.S.C. 1927 and the court's inherent authority. And so that's about frivolous actions and things like that. In seeking fees, Consequence noted that at the same time as this action, Liebowitz had filed 3 other actions in this court, all against entities based in Chicago, and so in this court means the Southern District, which is improper, ascribing a vexatious motive to Leibowitz's inappropriate forum choice. Now, wait a second. Was this wasn't around the time that he got disbarred from the Northern District of Illinois, was it? I don't think it was. I think it was before
totally
that.
Was.
Oh, it was. So he couldn't file in the Northern District of Illinois, possibly.
I think he filed all of the Illinois things sort of at the same time. And
Okay.
so the result of some of those cases was...
Okay. In seeking fees, Consequence noted that the same time as this action, Liebowitz had also filed 3 actions in this court, all against entities based in Chicago. Ascribing a vexatious motive to Leibowitz's inappropriate forum choice, Consequence argued that Liebowitz should personally be ordered to pay their attorney's fees, arguing, quote, that Liebowitz agreed to an open-ended extension of time for Consequence to answer the complaint, then turned around and moved for default without giving notice required by the law, violating a specific court order to comply with that rule. He then moved for default judgment, still well aware that jurisdiction and venue were improper, needlessly increasing the cost of litigation for Consequence. Were those the consequences of his actions? Consequence further noted that its counsel, Dan Booth, had in fact notified Liebowitz October 2018 that venue was inappropriate in this action while representing a different client in a wholly different action nearly a year before Booth even entered an appearance in this action. Indeed, Consequence alleges that Leibowitz's filing of this case in this district is part of a pattern in which Liebowitz seeks to evade the local rules of the Northern District of Illinois, requiring appointment of local counsel and posting a bond by filing cases against Chicago defendants here. So that's what it is. He doesn't want to appoint local counsel or post bond. In support of this unusual contention, Consequence presented extensive evidence regarding Liebowitz himself, noting that in the course of his extensive copyright litigation practice, he has been subject to numerous motions for sanctions in the past, and has been criticized by federal judges in previous cases as routinely bringing claims that do not result in substantive litigation. In addition to numerous judicial opinions sanctioning Liebowitz and criticizing his conduct, Liebowitz has been profiled by national media as a copyright troll. Hey, today we learned we are national media. Oh, they're referring to Justin Peters' Why Every Media Company Fears Richard Liebowitz in Slate, and Alison Frankel, Manhattan federal judges are getting fed up with notorious copyright troll Reuters. Boo! They should have chosen a site from lawful masses. I don't know that our videos count. In its motion, Consequence sought to recover $21,000 in attorney's fees for 50 hours of counsel Dan Booth services to date at $425 per hour. On September 10th, Ward filed for voluntary dismissal, and this court closed the case the next day, leaving Consequence's motion for sanctions still pending. On January 10th, 2020, Consequence filed an additional motion for attorney's fees, noting that Liebowitz had not responded to its previous motion. Consequence argued that his subsequent voluntary dismissal of a similar claim in the Northern District case operates with prejudice and makes Consequence the prevailing party entitled to its attorney's fees under 17 U.S.C. 505. Liebowitz responded to that claim that voluntary dismissal should be without prejudice, ignoring the clear language of Federal Rule of Civil Procedure 41, stating that if plaintiff previously dismissed any federal or state court action based on or including the same claim, the notice of dismissal operates as an adjudication on the merits. In other words, you don't get more than those 2 bites at the apple. Liebowitz further claimed that Consequence's motion was not timely, citing Federal Rule of Civil Procedure 54, for the proposition that a motion for fees must be filed no later than 14 days after judgment, ignoring the fact that Consequence filed its motion concurrently with its motion to dismiss before judgment was entered. Consequence has raised 2 independent bases upon which the court could impose sanctions. Under 17 U.S.C. 1927, the court may impose sanctions upon attorneys who unreasonably and vexatiously multiply proceedings in a case. Such sanctions will be appropriate when an attorney has acted in an objectively and unreasonable manner by engaging in serious and studied disregard for the orderly process of justice. Regardless of its statutory authority, the court's inherent authority provides an independent basis for it to assess attorney's fees when a party has acted in bad faith, vexatiously, wantonly, or for oppressive reasons. In addition to these bases for awarding costs against Liebowitz, 17 U.S.C. 505 and 1203 grant the court discretion to award attorney's fees to a prevailing party in a copyright action, creating exceptions to the standard American rule by which parties bear their own costs. It is a simple matter for the court to conclude that Liebowitz's conduct in this case has been irresponsible, unreasonable, and detrimental to the fair administration of justice, harming both Consequence, the court, and even his own client, who has lost his opportunity to advance what appears to be a meritorious claim. Even without the ample evidence on the record as to Liebowitz's consistently poor practice of law in other jurisdictions, his filings in this case do not indicate any basis upon which Liebowitz could have thought that this court was the appropriate venue for this action, leading the court to conclude that he likely filed this action in bad faith as a frivolous effort to harass Consequence. Liebowitz's conduct in proceeding with an action after being notified that this court was an inappropriate venue, then seeking a default judgment without notifying the opposing party, further demonstrates a tendency to vexatiously and unreasonably create frivolous work for the court. While the undersigned is generally inclined to give attorneys the benefit of the doubt based on the sheer volume of cases that Liebowitz has filed, the court feels he should have known better by now. That said, while Liebowitz may be an example of the worst kind of lawyering, the court is not inclined to forget the larger picture and the basis for this claim. Consequence conceded early on that it did use Ward's intellectual property without permission. It has never advanced any good reason why it published his photograph without seeking consent and offering payment. Misuse of intellectual property has become a pervasive problem in the internet era, and one that is especially pernicious for freelance photographers like Ward, who often lack the resources to pursue claims in court against organizations like Consequence, knowing that even if successful, they may receive mere token payments of a few $100s for their work, far less than their legal fees. For a discussion of the difficulties of copyright enforcement in the context of freelance photography, see Jessica Silby, Eva Subotnik, and Peter DeCola, Existential Copyright and Professional Photography, Don Tomlinson and Christopher Harris, Freelance Photojournalism in a Digital World, Copyright Lanham Act and Draught Moral Considerations plus Sui Generis Consideration. Aggressive plaintiffs' attorneys such as Liebowitz then can be said to represent the fetid backwash of online media providers' own persistent and willful disregard for intellectual property norms, and the court is not overly sympathetic to Consequence's plea to be made whole. Further, the court notes that the persistent confusion in this case is not solely the fault of Liebowitz. Consequence never answered the complaint, made no filings in this court until August 2019, approximately 9 months after it was served, and it does not even appear to have retained counsel in that 9-month period. While Consequence blames Liebowitz for its failure to respond, noting that he never notified the court of the agreement to extend the response deadline, Consequence also made no effort to notify the court that it had entered settlement discussions with Ward or that it felt venue was improper. When settlement discussions broke down, Consequence seemingly ignored the fact that litigation remained pending in this court, perhaps expecting, ostrich-like, that Liebowitz would vanish if it simply stuck its head in the sand and did nothing. Consequence finally did emerge from its torpor and take an interest in this case, with Dan Booth entering an appearance as Consequence's counsel. The court was intrigued by Booth's claims that he had discussed the case with Liebowitz 10 months before he represented Consequence. Taking judicial notice of other similar proceedings and Booth's own website, the court observes that Booth has found himself opposite Liebowitz with some frequency in forums across the country. Dan Booth has vigorously defended a variety of media companies facing the same attorneys Leibowitz's trumped-up litigation claims. The court does not wish to encourage personal disputes between individual attorneys that extend across multiple representations, and in this context, it is logical to look with some extra skepticism on Dan Booth's motivations in pursuing this representation and his estimates of his fees. Based on its own inherent authority, the court will sanction Liebowitz in the amount of $20,000, a sum which represents the court's estimate of Consequence's reasonable legal fees, as well as the expenditure of the court's resources. Half of this amount will be paid to the court, with $10,000 in fees awarded to Consequence. The court hopes that Consequence's remaining uncompensated financial expenditure and the experience of wrangling with legal lampreys such as Liebowitz will serve to ensure that Consequence in the future exercises the merest modicum of caution necessary to avoid misusing the intellectual property of others. For the reasons set forth above, the court grants, in part, the motion for sanctions, and sanctions Liebowitz and his firm for the vexatious and bad faith practice pursuing this claim. Within 30 days, Mr. Liebowitz and Liebowitz Law Firm jointly and severally shall pay monetary sanctions to the court in the amount of $10,000 and fees to Consequence in the amount of $10,000. Within 1 week of receipt, Consequence shall file proof of payment. The court continues to retain jurisdiction to impose any additional sanctions as necessary. Consequence's motion to file supplemental authority is denied as moot. It is so ordered. Nancy Rosenstengel, Chief U.S. District Judge for the Southern District of Illinois, May 7th, 2020. So he got a $10,000 award against the or for the consequences of his filing against Consequence, and a $10,000 sanction to be paid to the court. So yeah, that's another $20,000 sanction for Liebowitz. Let me know what you think of that in the comments below. Liebowitz is just racking up all of these sanctions. I kind of wonder when they will actually come back to bite his law license. We'll keep track of it. I have an alert out for all Liebowitz cases, and we'll keep track of them and present them as they keep coming.
I just get really concerned. I never want to be in the position where a judge starts inventing language in order to describe me, like a legal lamprey.
Yeah.
Like, the judge has an opinion here.
Now, lamprey are those sucker fish, right? They like latch on and they suck the blood out of somebody. It's out of somebody, like kind of like a leech, but it's a fish. And it's got teeth. It's got like a circle of teeth, and it cuts like a circle into your skin or into its victim's skin. And then it like sucks out the blood and nutrients and things that are
stuff of nightmares, I tell you.
Yeah, really. Not the same thing as those little plecos that clean other fish. Those are nice guys.
And I think that the judge does a good job at separating Liebowitz from his clients, because a lot of his clients do have meritorious cases, and a lot of them are being legally harmed. I think that it's just the way that Liebowitz is running his firm that he's not able to represent things competently.
He has too many cases.
Just too many cases. 25
complaints in a month. He's assuming that most of those are going to settle, and he only needs to handle one. And I don't think that that's realistic. Even if 95% of cases settle, I still don't think that's realistic. So that is our show, everyone. Thank you for joining me. I'm Leonard French, your favorite copyright attorney, and this is our legal education and legal news channel, Lawful Masses. Support us on patreon.com/ljfrench and sponsus.com/law if you are able. It really helps our channel out and makes it possible to make these videos at all in the first place. Thank you very much to our $50 plus supporters in the month of May. I love how long this list is. Joe Tyson, Wes Delj, Nicely Done Defense, Video Remonetized, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Michael Pearce, Daniel Perez, Blackleaf, Benjamin Hitov, Stephen Ottah, Cute Grills in Your Area, Longreach Jones, Zachary Chaney, Mullen PC, Ugly Grill, Shielo T, Josh Baker, Gregory, and Rudolph Bescherer Jr. And the $5 plus supporters are scrolling on the LED matrix panel next to me. I am Leonard French, your favorite copyright attorney. I will see you in the videos that drop. I love you all. Stay safe, stay healthy. We're going to get out of this whole thing together safely. Bye.